I would like to discuss on insanity as a legal defense under Section 84 of IPC. And the meaning of insanity is the condition of being seriously mentally ill. And under Section 84 of IPC, Indian Penal Code, it says that any act done by a person who is of unsound mind at the time of doing act, and the person is incapable of knowing the nature of the act, and the person does not know that the act which he is doing is wrong or contrary to the law. The origin of this law of insanity is from the McNaughton's case. There were various tests used to declare a person legally insane, such as wild beast test. This test was the first to check the insanity laid down in the case of Arnold. In this case, it was held that if a person do not have the capacity to determine that what he is doing is right or wrong, then he would get insanity defense. Then came to the insane delusion test and test of capacity to distinguish between these right or wrong. And these three tests laid down the foundation of this McNaughton's case. And in 1843, the accused McNaughton was suffering from persecution mania, and because of this disease, he thought that whatever the difficulties he is facing is because of British Prime Minister Robert Pell, and McNaughton shot Mr. Drumpton, believing under a mistake that he was killing Prime Minister, who was the private secretary of Prime Minister, and this happened because McNaughton was sick. So he pleaded insanity and the House of Lords acquitted him. These generated a lot of public sentiment and lot of pressure was put on the House of Judges, and they constituted a special committee of judges and laid down the rules for plea of insanity, and this is known as these McNaughton's rules. And those rules were, first one is, all are presumed to be sane until contrary be proved for the satisfaction of the court. To claim the defense of insanity, one should clearly show that at the time of the act, the accused was suffering from the defect or mental illness, and at the time of doing act, he did not know the nature of that act. And the last rule is that at the time of doing the act, the accused do not know that what he is doing is right or wrong. English law considers insanity as a valid defense. The definition of insanity is based on these McNaughton's rules. And Indian concept में insanity को ऐसे कहा गया है कि in India the law on this subject is mentioned under this section 84 of IPC, as I have told. The provisions are same as mentioned in these McNaughton rules held by the House of Lords, by this section of 84, which use a more comprehensive terms, unsoundness of mind, rather than the word of insanity. There are some essential ingredients for this section of 84 of IPC, which are act must be done by a person of unsound mind. Such person was unsound at the time of committing that act, and such incapacity should be of unsoundness of mind of that accused. Such person was not capable to know the nature of the act, or the act he was doing was either wrong or contrary to law. अब हम जानते हैं कि लीगल इंसैनिटी एंड मेडिकल इंसैनिटी के बीच डिस्टिंक्शन. It is important to note that insanity plays a vital role in criminal law, and it is legal sense is to be understood rather than medical sense in order to claim defense under IPC. Legal insanity is narrower than medical insanity because some illness which are termed as insanity according to medical science, but it cannot fulfill the criteria of legal insanity in order to get the defense under this Indian Penal Code. There are some incapacity to know right or wrong. In order to use the defense of insanity, It is not mandatory that both the requirements mentioned in the section have to be fulfilled. A person, if able to know the nature of the act but not able to know what was wrong or contrary to law, can still get insanity defense. And the burden of proof in the cases of insanity is proving the offense is always on the prosecution. The prosecution has to prove the offense beyond reasonable doubt. But onus of proving the elements mentioned in this section 84 of Indian Penal Code are on the accused. To claim the defense of insanity, defense have to be proved that at the time of occurrence of the incident, accused was unsound mind, and the rule of this burden of proof in cases of insanity. Or as prosecution have to prove the prosecution have to prove the reasonable doubt that offense was committed by accused with mens rea, and insanity is a rebuttable presumption. The accused can bring oral, circumstantial or documentary evidence to rebut the presumption of sanity, and at the time the claim defense of section 84 of IPC, and the accused do not have to prove elements of section 84 beyond reasonable doubt. एक केस लॉ है श्रीकांत आनंदराव भोसले versus State of Maharashtra. In this case, it was happened that the accused was a police constable, and the wife was hit on the head with a grinding stone by the accused, and she was immediately taken to the hospital but was found already dead. After investigation, the appellant was charged for the offense of murder. Insanity was pleaded as a defense in this case, and the appellant had the family history where his father was also suffering from mental illness, so the reason for such an ailment was not known. The appellant was undergoing treatment for these mental diseases, and it was observed that the motive for the murder was quite weak. And also, after killing his wife, the accused did not attempt to hide or run. So based on these facts, it was decided that the accused was suffering from some mental illness, and insanity defense was accepted. And though he was not guilty of murder, he was given the benefit of section 84 of IPC under insanity as a defense. Thank you.